and a total of 6 papers will be presented in this session. Due to the time constraints, we had requested our paper presenters to prepare different presentations to conclude their presentations in 7 to 10 minutes, and they gracefully honored our request. I would once again request the presenters to keep the time constraint in mind. The first paper that was shortlisted is on a very interesting topic. Its title is Dilemma of Separation of Powers Among Civil Institutions in Pakistan, a case of presidential ordinances promulgated during the years 2018 and 2019, and has been written by Dr. Asma Rashid. She is lecturer in Department of Politics and International Relations, International Islamic University, Islamabad. I request Dr. Asma Rashid to come on stage and present her paper. Dr. Asma Rashid.
Assalamu alaikum everyone, and in the name of Allah, the most compassionate, the most graceful, I would like to start my presentation. But before that, I would like to thank my heartfelt gratitude to the Kahuta Law College and to my institution IIUI, that is basically a constituent part of International Islamic University, for providing us this opportunity to present our views at this intellectual forum. And we hope, and we should hope, that inshallah this is going to bring a change in the Pakistan judicial system. So starting off with our today's presentation, this is quite a sensitive and a very critical issue that deals with the dilemma of separation of powers in Pakistan. And basically this analysis, or my research paper, focuses on the year 2018 and 2019, that how many presidential ordinances have been promulgated and how they have affected the judicial implementation, or how they have proved as an impediment in bringing the reforms in the judicial system of Pakistan. I will try to stay brief, keeping in view the time constraint. So let's begin with it. Basically, governing a state is a far more complex than it appears, particularly in a democratic context like Pakistan, where issues of governance are deeply embedded across various branches of the government. So my study basically examines the loopholes that allow for the frequent promulgation of presidential ordinances during the year 2018 and 2019. Basically, under Article 89 of the Constitution, the President of Pakistan is vested with this power to issue presidential ordinances, and basically these presidential ordinances are the temporary laws that carry the authority of an act. While many constitutions worldwide grant similar powers to the executive, typically reserved for emergencies, the use of these powers in Pakistan has been notably very frequent. The government often justifies such actions in the name of public interest, whereas the opposition may either challenge them as an unconstitutional or remain silent. So this exploratory study investigates the underlying weaknesses within the Pakistan legislative system that enable the executive to unilaterally impose laws through ordinances. So by exploring the structural gaps that compromise the balance of power between the various branches of the government, the three institutions of the government, legislative, executive, and the judiciary, this paper offers recommendations that aimed at strengthening the legislative branch to enhance the separation of powers and preventing the fusion of authority that undermines democratic governance. Basically, my study answers 5 questions. I'm quickly jumping to the questions and their answers in order to save time. First question is what the Constitution of Pakistan says about the presidential ordinances. Second is why the demarcation of the use of power not clear among the executive and legislature in Pakistan. Third, what presidential ordinances were promulgated during the year 2018 and 2019 by the then government. then how can the legislature be strong enough to satisfy the needs of the constituents in terms of law making? And the last question deals with what are the limitations of the separation of power theory. So moving on to the separation of powers concept among the civil institutions of Pakistan, basically we do have a parliamentary setup, and that is established under the 1973 Constitution of Pakistan, that follows the principle of separation of powers, with the Prime Minister as the head of the government, while the President, he is given the ceremonial powers and he is basically the head of the state. However, separation of powers meant to balance the functions of the legislature, executive and the judiciary. But it has struggled to work, usually it works effectively. However, in practice, the executive often overrules the judiciary and legislature. That in turn disrupt the political system and hinders the true democracy in Pakistan. While the legislature is tasked with making laws and keeping the executive in check, its influence is often undermined by the regional differences, political party control, and a lack of qualified representatives. Similarly, our judiciary faces undue interference and a lack of, they used to face interference and bureaucratic pressures that basically weakens its role as the protector of the constitutional rights. So this imbalance of power has led to inconsistencies and inefficiencies and a lack of transparency and a failure to address public welfare, resulting in a continuous power struggle that hampers the state democratic progress. I would like to quote here a French statement or a proverb, "Le pouvoir arrête le pouvoir." Like that means that power holds power. So basically, the mentality or the thinking behind the separation of power concept was that they wanted to keep a check on the lethal impacts of unrestrained power. That's why they opted for this separation of powers among the different institutions of the state. For strict securitization that undoubtedly hindered the totalitarianism within state institutions. But unfortunately, it is not working well within Pakistan. Now moving on to the questions. The first question, that what Constitution of Pakistan says about the presidential ordinances. As I mentioned earlier, this is the Article 89 of the Constitution that grants this authority to the President of Pakistan to promulgate temporary laws that carry the weight of an act. These ordinances can be issued when the National Assembly is not in session, allowing the President to address urgent matters without going through the normal legislative process that is quite lengthy. However, the Constitution also sets certain limits, and these ordinances must be approved by the Parliament within a specified time frame or they lapse. While intended for emergencies, the frequent use of overarching powers of the executive and the bypassing of democratic processes in Pakistan is really evident if we see into the history of presidential ordinances in Pakistan. Then the second question is, why is the demarcation of the use of power not clear among the executive and the legislature in Pakistan? So the answer to this question is that the demarcation between legislature and executive is often unclear due to overlapping roles and frequent overreach by the executive branch. So while the legislature is responsible for making laws and holding the executive accountable, led by Prime Minister, sometimes they bypass the legislative process by using the tools like presidential ordinances. Then there is a list of presidential ordinances that were promulgated during the last decade, 2013 to 2018, and then to 2018 to 2019. And this goes list, it is a very long list. And during the single year in 2018, during 2018 and 2019, there were 27 presidential ordinances that were promulgated. And if you look into the history since 1947, government of Pakistan, civil or military, has been passed almost 25 ordinances so far. And a very famous political scientist, Dr. Ralph Bray-Benty, who has done extensive research on such matters related to Pakistan, wrote that the federal government has passed 459 ordinances from the year 1947 to 65, and then 17,770 ordinances after 1965 till the period to 2019. This number is quite alarming. So now I have to conclude because of time constraint. So the issuance of presidential ordinances often indicates a weakness within the legislature, as it is not typically the executive preferred method of lawmaking. So rather than focusing on criticizing the use of ordinances, policymakers and now I would request this entire law community to take a prerogative, and they should address the underlying issues within the legislative process that make such measures necessary. According to Article 89, ordinances can be issued when Parliament is not in session, but Parliament can generally be convened at any time, making the timing argument less relevant. Additionally, ordinances are intended for emergencies such as wartime, which has not been a recent concern or during this 2018-2019 period. Therefore, using ordinances in ordinary circumstances undermines the democratic principles. And as Babar Sattar, the very respected lawyer, he said that the president should not be viewed as an ordinance factory, and he emphasized that this unilateral power should not be a regular substitute for proper legislative process and listening to it. Thank you.